Mistake number 2, no plan to control financial and property matters during incapacity. And this is a problem that you'll also see with the healthcare matters. Without the appropriate legal documents to manage your assets during incapacity, a court-supervised conservatorship is probably inescapable. So what is a conservatorship? A conservatorship is a process where your loved one needs to have the authority to manage either your healthcare decisions or your financial decisions. They need to file a petition with the court, hire an attorney to be appointed a conservator. So if it's a conservator over your estate, it means they have the authority to manage your financial decisions. If it's a conservator over your person, that means they can manage your day-to-day decisions and your healthcare decisions. It's a very lengthy process. Begins with hiring an attorney. They file a petition with the court. The court then appoints an investigator who goes out and meets with the proposed conservatee, determines whether a conservatorship is appropriate, make sure that there's no elder abuse going along. And if you are the proposed conservator, the person who wants to manage your loved one's finances, well, now they're going to investigate your background and make sure you're not a credit risk and that you're not going to mismanage those assets. So it's a very time-consuming process. And if we have a loved one who's on the border, it's not real sure, or it's not clear whether they're a candidate for a conservatorship, the court's going to ask them whether they want a public defender appointed. And that public defender is now going to defend your loved one from this conservatorship, and that public defender is not going to get paid from the state. They're going to ask to be compensated for all their time from your assets. And so that's why it's very important to try to avoid a conservatorship with pre-planning. And how do we do that? One way is to establish a living trust. With the living trust, we can transfer our assets into this entity, such as our home, any real estate, bank accounts, brokerage accounts, and with respect to any asset that we have transferred in the name of the trust, the individual who we've named as the successor trustee can step in and manage those assets. So they can go into the bank accounts, pull money out to provide for our care. So if we're in a care facility, well, they can use that money to pay for those expenses. Or if we're in home, they can use that money to pay for in-home supportive services, buy the groceries or other things that we need. Otherwise, it may be difficult to get access to the bank accounts and get access to the funds that they need to provide the level of care necessary. However, there are other areas of your financial life that are not easily transferable into a living trust. So most frequently is the mortgage. You can't transfer your mortgage into the trust, so we would need a durable power of attorney to allow someone to be able to talk to the mortgage company. Maybe it's ripe for a refinance, or you need to talk to the mortgage company about doing a modification, or you've gotten to the point where you need to sell mom or dad's house. Well, we need a durable power of attorney for you to be able to act on behalf of mom or dad in that situation. So powers of attorney usually are in the form of what we call a limited power of attorney. So if you have a financial advisor, when you have assets under management, chances are that financial advisor has a limited power of attorney to buy and sell assets on your behalf. Or if you've entered into a real estate transaction, you may have executed a limited power of attorney in that situation as well. And they're limited because the moment you become incapacitated, that power of attorney is no longer valid. So that's why we need the durable power of attorney, which goes beyond incapacity and typically would terminate upon divorce, death, or revocation. And with the power of attorney, we have a couple options. We could prepare an immediate power of attorney, meaning my wife at the end of the table, Chelsea, I execute a power of attorney, I name her the agent. She can take that document immediately to the bank and she can get access to my bank accounts. And I trust her, so that wouldn't be a problem for me. But for some of you, you may be uncomfortable having your attorney, in fact, your power of attorney having immediate access to your financial assets. So we could prepare what's called a springing power of attorney, meaning means it springs into effect upon the occurrence of a stated event. And that event most frequently is a determination of incapacity. So we could establish what I like to call a disability panel. A panel of 2, 3, even 5 of your closest friends and neighbors, and they can get together, and when a majority of them decides, hey, he really doesn't have the ability to manage his financial affairs, well, at that point, now that power of attorney is valid, and the agent named in that power of attorney can act on your behalf. The determination also can be made by a primary care physician, or a court determination, or an unexplained disappearance, detention, or absence of greater than 30 days. A power of attorney that is not well thought out can not only be ineffective, but may be even counterproductive in achieving the principal's overall objectives. So you want to sit down with an estate planning attorney, think about what it is you're putting together, what your needs are, and to make sure that that power of attorney addresses those needs. Frequently, provisions left out of a power of attorney include the ability to sell a home. I was speaking with a realtor just this week about a client who wants to sell a mom's house with the power of attorney. And they informed me that now title companies, they don't just want a durable power of attorney, they want to see a specific authorization with respect to that exact piece of property. So those are things that need to be contemplated and need to be addressed when you're putting these documents together. The ability to care for the pets. We want to make sure that Fluffy or Fido are well taken care of, that someone who knows how much we love our pets will step in and give them the care that they need. And then the power to fund trusts. So you may be incapacitated for a short period of time, or you may receive an inheritance, maybe another piece of property. We may need your power of attorney to step in and transfer that asset into your trust so that we can avoid probate. Additionally, for some clients, we're creating specialized trusts, irrevocable trusts. So we may create a VA trust to help you qualify for a VA pension if you've served in the armed services during wartime, what we call a Medicaid trust to help you qualify for the long-term care benefits associated with Medi-Cal. Well, we want to be able to fund those trusts if you're incapacitated. So we need to see that power in the durable power. And then, frequently left out is the power regarding U.S. mail. If we receive a priority package to the house, we're not there to receive it. It gets sent back to the post office. We want somebody to be able to go to the post office and collect that on our behalf.